Greetings viewers, thank you for your votes on my previous videos on ESOPs. In case you've not seen them, you could scroll over to the previous video and watch one on ESOPs as well. Coming to the topic that we'll be discussing now is on the drafting of suppression clauses in the matters of employment. We live in an era of information age. Now this age is called the information age because information is pivotal to any person's success. Businesses flourish based on the sensitive processes that they are prone, the technological advancements that they have undertaken, and the competitive edge that they have over other competitors. As such, it becomes pivotal to ensure that the success of every business or an organization depends on how it secures this information. In this lecture, we will be discussing about the various advancements in the drafting of suppression clauses, their law and policy in India. Suppression clauses or restrictive covenants act as an impediment to exercise your rights freely. In today's session, we will be discussing about three of the major clauses which act as a suppressive clause and provide for restrictive covenants. The first clause that we will be discussing for today is the non-compete clause. The non-compete clause today has become one of the major boilerplate provisions in every contract. Well, I am amused by the fact that majority of the contracts even till today have a non-compete clause. Now, based on the various decisions, it is reasonable for me to say that non-compete clauses are applicable as long as the employment of the person continues. However, in case of post-termination of employment, such clauses cease to have any impact. In India, it is only the clauses that have a pre-termination impact are held to be enforceable in an employment scenario. As such, the availment of garden leave clauses is something that is an innovation that has come across in the field of contract law. In such a scenario, businesses find it difficult to protect their own interests in the form of a non-compete clause. As such, there is one particular way wherein businesses can protect their interests. One of the mechanisms is that the employees receive often exposure into the business areas of the organization that are either on the horizontal or on the vertical plane. Businesses may execute non-compete clauses with the businesses that they are having transactions with. The existence of non-compete clauses within two business entities has always been upheld by the courts as not to be a restraint of trade. The second array of a restrictive covenant or suppression clause that we will be discussing is that of the non-disclosure and confidentiality clause. In respect of a non-disclosure agreement or a confidentiality agreement, it is quite amusing further that generally these clauses are defined in such a wide ambit to include everything that has been discussed in the process. Such a wide ambit of drafting, although said to be requisite to protect the information of the company, however, would be a bad drafting practice on the following count that not all information that is transmitted in a business would become confidential. Confidential, the term, has to be interpreted in the manner wherein it is necessary to include only such information that are truly the essence of its term. As such, the same should be well defined in a contract rather than keeping a wholesome generic definition. Only information that has been received in trust of the employer by the employee can be held to be a confidential information. Despite the fact that the employee has put in his efforts in developing the confidential information, he, however, can claim no propriety on such aspect. The courts have often held that the clause relating to confidentiality is implicit in every employment. The final clause of suppression that we will be discussing next is with regard to the non-disparagement clause. The non-disparagement clause or agreements are fairly nascent in India and have not yet been tested or tried by the courts. The term disparagement is something that may be interpreted to mean a statement that is either unflattering against someone or something. In 2018, Infosys was one of the leading listed companies in India which have executed several non-disparagement agreements with its exiting senior management personnel. Based on its disclosures in the 2018 annual report, it seems to have executed non-disparagement agreements with its former board members, including the chief executive, Mr. Vishal Sikka. A perusal of this non-disparagement agreement on an informal note seems to be something that goes against morals of public law and policy. The challenges to the same are based on the aspects of whistleblower law and protection, wherein an existing employee cannot be restricted from disclosing the truth for greater public good. How can an employee who has been terminated from services be restricted from doing the same? With this, we move on to the last leg of our discussion today as to what is the impact of an arbitration clause in any of the contracts wherein the above mentioned clauses are present. Now, it is pertinent to note in 2008, the Supreme Court has decided that where an arbitration clause is prevalent, it becomes difficult for the courts to intervene into the nature of the facts and circumstances of the case and discuss the merits as to the breach of a non-compete or a non-disclosure or a non-disparagement clause. As such, it may just be said that while drafting an arbitration clause, care and precaution has to be taken to ensure that an escalation clause is mentioned therein. There is a provision for drafting of escalation clauses so that the remedy from the courts are not taken away. With this, we have come to the conclusion of our session today. Look forward to have a discussion from you. Feel free to give back your feedback and comments in the section below. Thank you.